Ladies and gentlemen, welcome to our next sessions. We're honored to have Ms. Emmanuelle Ta to give us the next speech about, she is CEO of eBRAM, International Online Dispute Resolution Center Limited. She has 15 years of experience in international arbitration and case management. She has handled many cases. However, today she's given a very interesting topics on the launch rockets, not rocks at your space partner. So we're excited to have Emmanuelle to talk about this interesting subject, which is new to, probably new to each one of us. Thank you. Let's welcome Emmanuelle Ta. Thank you.
Thank you very much, Justin, for the kind introduction. In my 15-year career in international arbitration, I cannot recall encountering any disputes related to space matters, but this should not be seen as arbitration being unsuitable for resolving such disputes. On the contrary, the dispute resolution community is increasingly recognizing the importance of the space industry, as evidenced by the publication of arbitration rules by certain arbitral institutions to specifically address space-related disputes. The conference we are attending today serves as a testament to the rapid progress of the space industry, with the dawning of the space industry in the Greater Bay Area, the growth of the space industry in Hong Kong, and China's rising commercial space sector. As the new space economy continues to expand, and with the increasing activities in space, disputes related to space will inevitably arise. Therefore, it is crucial to establish effective mechanisms for resolving such disputes. Given the diverse ecosystem of the space economy and the involvement of various stakeholders, a range of disputes can arise. This may include high-stakes conflicts involving government agencies, private companies, investors, research institutions, and international organizations. These disputes involve usually highly confidential information. Highly sensitive knowledge and technologies are at stake, so it is undesirable for research and development results to leak out during the dispute, which may damage the reputation of stakeholders. Other disputes may arise between the space service provider and the end users being the consumers of space-based products and services. The consumers comprise of businesses, governments, and individuals who rely on satellite services, telecommunications, and more. So the question that arises is, what is the most suitable forum for resolving space-related? Today, I will discuss why arbitration and mediation are your go-to choices for resolving space disputes and how eBRAM caters to the unique needs of this emerging sector. Mediation is an option for high-stake disputes. Usually, a lot of investment and research time has been sunk into a project, and the best way out of a dispute and to further initial development objectives is by way of mediation. Mediation is a confidential process where a neutral third party called the mediator assists the disputing parties in reaching a mutually acceptable solution. It encourages open communication and helps parties explore creative options for resolving their differences. Mediation is a dispute resolution mechanism to help disputants look for collaborative opportunities going forward, rather than engaging in backwards-looking blame game. It also serves as a great first or second stage in a multi-dispute resolution mechanism. On the other hand, arbitration is a more formal process, but private, where an impartial arbitrator or a three-member arbitral tribunal will issue a binding decision based on the arguments and evidence presented by the parties. Arbitration procedures are private and confidential compared to court proceedings. Arbitration enables parties to appoint arbitrators with technical expertise in the field to decide on the matter. This will ensure that the dispute is resolved by professionals who have the necessary knowledge and experience in the space industry. Arbitration is also a flexible process and moves much faster than litigation, as the parties and the arbitrators may agree to a procedural timetable for the resolution of their case. Arbitral awards rendered by arbitral tribunals are also enforceable in over 172 countries under the New York Convention. I would also like to discuss an innovative solution in the field of online dispute resolution, eBRAM online dispute resolution or ODR services, which can play an essential role in resolving space-related disputes efficiently and fairly through online mediation and online arbitration. Now, let me introduce you to eBRAM and eBRAM services. eBRAM International Online Dispute Resolution Center was established in Hong Kong in 2018. It is a law tech company and a mediation and arbitration institution that has law tech or ODR capabilities. eBRAM is also listed as one of the 7 institutions eligible to apply to the mainland courts for interim measures for Hong Kong-seated and administered arbitrations. This arrangement allows parties to a Hong Kong-seated arbitration and administered by eBRAM Center to apply to the mainland courts for interim relief against mainland-based counterparties. While eBRAM is an independent and private company, it enjoys the support of the Hong Kong Department of Justice, the Law Society of Hong Kong, and the Hong Kong Bar Association, as well as the wider support of the dispute resolution community. Now, what is ODR? What is online dispute resolution? ODR is about moving the entire mediation and arbitration proceedings online. It is about having a collaborative platform to support your case while it is proceeding, allowing the parties to participate and access the case file from anywhere. ODR is suitable for resolving space-related disputes because parties to the dispute are often located in multiple jurisdictions. So online procedures, tools, and integrated video conferencing platforms help save on time and travel cost. Adopting the eBRAM arbitration or mediation procedures and the eBRAM online platform enables parties to focus on important strategic decisions in space business development instead of managing the logistics of a dispute. As eBRAM is both a mediation and arbitration institution, it can also assist the parties in appointing arbitrators to convert settlement agreements from mediations into legally binding consent awards, such that if one party fails to comply with the terms of the settlement agreement, the other party can seek enforcement through appropriate legal channels. Now, let's take a look at the features of the ODR platform developed by eBRAM. The commencement of the ODR mediation or arbitration process can, at the option of the parties, be done online through a web form, which is a guided process. Parties can then share relevant information and documents with the mediator or arbitrator and the counterparty. The document exchange feature on the ODR platform provides large amounts of storage space for parties and the arbitrator to utilize. Emails also take time to manage. If you are a business person, your emails relating to your dispute would very likely get mixed up with your emails. It can be cumbersome and time-consuming to isolate the emails, documents, and information relating to the matter. However, if the parties utilize the document exchange and sharing function of eBRAM's ODR platform, the information will already be in one place right from the beginning. The platform also allows the parties and the mediator and arbitrator to communicate directly on the platform so that there can be less email traffic. It also allows the consolidation of the communications in one place and serve as a record of the relevant communications. This can be useful to the parties if they wish to quickly refer to past communication directly on the platform during mediation or arbitration process. The eBRAM system also integrates an AI machine translation to translate any submissions exchanged and uploaded onto the platform. We also have video conferencing capabilities baked right into the system, so it would not be necessary for the parties to make extra arrangements and send meeting links to all concerned before each meeting. One great feature of the video conferencing function is that it integrates machine real-time transcription capabilities. And again, this will help you save time and cost. Finally, if the mediation is successful, it is necessary to draft and sign the settlement agreement as soon as possible to secure the new consensus. So with the integrated electronic signing feature, the mediator and the parties can swiftly upload a settlement agreement onto the platform to be signed, even if the parties remain in remote locations. The e-signing can be done on any computing device with an internet connection. And if the parties wish to have a more intuitive signing experience, they can also sign on their mobile phone by scanning a dedicated QR code. Now, why choose Hong Kong to resolve space-related disputes? Hong Kong offers a large pool of arbitrators, mediators, lawyers, and other professionals to assist parties in resolving their disputes. It is one of the top 3 most preferred arbitral seats in the world. Hong Kong is a pioneer of international arbitration in Asia, as the first major jurisdiction in Asia to base its arbitration legislation on the 𝗬𝗎𝗄 model law. Hong Kong benefits from a mature pro-arbitration judiciary made up of specialist arbitration judges and a court of final appeal comprised of permanent senior Hong Kong judges and non-permanent senior judges from common law jurisdictions, which demonstrates Hong Kong's understanding and support of the arbitral process. Another advantage is that parties to Hong Kong-seated arbitrations can access to interim measures from mainland Chinese courts. And as I have said earlier, eBRAM is also one of the qualified institutions under that arrangement. Awards rendered in Hong Kong are enforceable worldwide. Finally, Hong Kong has a satellite manufacturing center with a rapidly developing commercial space industry. The dispute resolution facilities available in Hong Kong are well placed to serve this new space economy. As an arbitration and mediation institution with ODR capabilities, eBRAM offers case administration services for arbitration and mediation cases conducted under its rules. As an institution, we also maintain a list of neutrals, mediators, arbitrators who are multilingual, international commercial dispute resolution professionals coming from different jurisdictions and with expertise in a variety of sectors, including the space sector. As you have just seen, eBRAM ODR services also include a secure and efficient platform for resolving disputes. eBRAM has published 3 sets of rules, such as the arbitration rules, the mediation rules, and the APAG rules. The APAG rules introduce a new and innovative expedited 3-stage process that includes negotiation, mediation, and arbitration, providing an affordable and quick resolution of low-value or non-complex cases. These rules are suitable for resolving space-related disputes, whether they involve commercial space activities, satellite operations, or other space-related issues. Now, to resolve disputes by ODR under eBRAM rules, first, the parties must have agreed to settle any disputes in accordance with the eBRAM rules. They can simply include one of the eBRAM model clauses appearing on the screen into their contract, or agree in writing after any dispute has arisen. The parties may also consider using either the APAG ODR, the arbitration, or mediation model clauses. All of eBRAM's standard APAG ODR, mediation, or arbitration model clauses can be found on our website, and they are also set out at the end of each set of eBRAM's rules. I will conclude by saying, as we venture further into the cosmos, it is crucial to have robust mechanisms in place to resolve disputes and maintain a peaceful and cooperative space environment. eBRAM ODR services offer an innovative and efficient solution combining technology and expertise. By embracing eBRAM ODR services, we can ensure that space-related disputes are resolved in a fair, timely, and cost-effective manner, fostering the growth and development of the space industry. I would like to encourage you to further explore online dispute resolution mechanisms as a means to resolve your space disputes. If you have any questions and would like to learn more about our services, our team is available and our contact details can be found on the screen. Thank you very much.
Thank you, Emmanuel. So it's apparently an excellent title. We should launch rocket, not rocks, as your partner. But in case you need to launch rocks, there's a civilized way to do it. That we can seek Emmanuel's help. I think based on the time, I think we can entertain one question. Are there any questions? Well, if not, then thank you so much, Emmanuel. So look forward to see you soon. Thank you.
Thank you very much for having me today. Thank you so much. It was a pleasure. Bye-bye.
Bye.